Now to the Seminole County Circuit Court in Sanford, Florida. It's 6:30 p.m. and a long one-day trial has come to an end.
We, the jury, find the defendant guilty of driving under the influence.
That defendant is 46-year-old Lisette Gonzalez. Although a verdict for Gonzalez's DUI charge has already been reached, her attorney makes a final plea to Judge Fred Schott.
Your Honor, not enough evidence presented for the jury to find the verdict that they did. They didn't do all the...
This isn't just a DUI trial gone sideways. This is a courtroom showdown over police accountability, prosecutorial ethics, and the limits of judicial patience. In just minutes, a Florida judge transforms what looked like a routine sentencing into a stinging rebuke of a broken case, calling out lies, clearing charges, and flipping the courtroom on its head.
The field sobriety examinations that should have been done.
During the trial, it was revealed that Gonzalez was never given a breathalyzer or had her blood drawn. Yet, arresting officer Michael Wagner recorded that she tested above the legal limit of .08 in his official report. Wagner claimed it was an honest mistake, but observed what he believed to be.
This violates due process under the 14th Amendment. A DUI conviction must rest on objective evidence, not fabricated numbers. Entering a known falsehood into an official report could constitute perjury or official misconduct.
To be intoxication.
I respectfully ask that this court grant the judgment notwithstanding the verdict.
The attorney is asking the judge to use his power to overturn the jury's verdict and acquit the defendant.
Gonzalez's attorney argues that no reasonable jury could find her guilty beyond a reasonable doubt. The judge initially denies the motion, wanting to respect the jury's verdict.
Defendant. It's a move rarely seen in the courtroom.
All right. This isn't a purely circumstantial case. And so I'm going to deny the motion for JOA.
It looks like the case is closed.
A judgment of acquittal, JOA, is rarely granted and only allowed when no rational trier of fact could find guilt. Judges must respect jury findings unless there's a clear legal deficiency, which the judge will later acknowledge.
Closed, but Judge Schott has other business with Gonzalez.
Now, we have this other case for driving while license suspended.
2 months after her DUI arrest, Gonzalez was ticketed for driving with a suspended license. Problem is, the only reason her license was suspended was because of the inaccurate paperwork filed by Officer Wagner.
This is an example of fruit of the poisonous tree, an invalid charge arising from a flawed or unconstitutional action. Once the foundation, the DUI, is discredited, derivative charges must be dismissed.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So you're going to null process.
Officers who knowingly falsify reports may be guilty of perjury under oath, false reporting, deprivation of rights under color of law, 18 U.S. Code, paragraph 242. The prosecutor's defense of the lie, not just the mistake, raises ethical questions under the model rules of professional conduct, especially Rule 3.8, special responsibilities of a prosecutor.
That case, or am I going to get mad at you today?
The judge is addressing prosecutor Diana Mears.
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
The judge has just dismissed the defendant's upcoming case, but he's not done yet.
This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
Judge Schott.
After re-evaluating the officer's testimony, the judge reverses his earlier ruling, granting the JOA. He explicitly states that Wagner had no probable cause and was not credible.
Schott has just reversed his decision and acquitted the defendant on the spot.
So you're granting it because you don't agree with the state's decision on
I'm
the
granting the
other charge?
JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? Appeal me.
Thank you, Your Honor.
The case should have never been done. Never.
Judges can revisit their rulings until the case is officially closed. In this instance, the JOA is legally valid because the only key evidence, officers' observations and false report, has been discredited. No objective evidence of intoxication exists.
Thank you for letting us know that, Your Honor.
The defendant, Lisette Gonzalez, walks out of the courtroom free of all charges.